Okay guys, so I'm just redrawing it for reference. We've seen these four aspects till now. There's plaint and written statement. Okay, we've covered till here for now. Now, the minute the issues get formed, once the issues are formed by the court of law, is when we say the trial is starting. Okay, because until now it's merely a stage of discovery of information, facts, evidence, etc. Now, let's say even before the trial really starts, there are a series of transactions that keep happening between the plaintiff and defendant. Okay, we'll call them as discovery. What do you mean by discovery? Sorry? Finding something, right? Finding something. Okay, we'll stick with that word. Discover means to. Oh, you said invent something. No. Let's keep it to. There's difference between discovering and invention. Invention is something new. Discovery is finding what is already in existence. Okay. Ultimately, before the court ends up framing the issues, he has to ensure that he has all the facts and matters at hand. Now, I'm not saying that discovery happens only before the trial starts or after the trial starts. It's an ongoing process. Okay, so I will actually call it as discovery and production of evidence. So, what do you mean by discovery? You're discovering certain evidence which was not produced before the court of law. So, let's say for example that the plaintiff is relying on some evidence, but he does not have the evidence with him. I'll give you examples going forward for better understanding. Let's say that Akash and say Ashray are brothers. Okay, they have to partition the property. They have not partitioned the property, and right now it's come to a dispute of the fact that Ashray has sold Akash's land. Let's say 1 acre goes to Ashray, another 1 acre goes to Akash. Now, what Ashray has done is he sold 2 acres of land, when in fact he can sell only 1 acre of land. Okay, now if he has sold the document, if he has sold the property, he would have had the documentation with him. Now, if Akash has to go before the court of law claiming that he is the real owner of 1 acre of property, then he should go and provide that document before the court of law. But that document is with Ashray. So then what can he do now? Can he say, Your Honor, the evidence is with the other person, hence I can't submit it to you? No. The court will direct Ashray to produce that evidence before the court of law. So, when I say discovery and production of evidence, they are doing a fact-finding process or asking one of the parties to produce the necessary evidence before the court of law. Now, this discovery and production in criminal matters can even relate to discovery of the murder weapon, because you can conduct a search and seizure, normally it is a search, of that person's premises to find out what exactly that evidence is there. So, say the example that I gave you was property related matter. What if it's a case of pollutants, air pollution or water pollution? We'll have to enter into that person's property, take samples of their water, and then only determine whether there's pollution, right? But for that, the court has to allow someone to enter into that property, take samples and check for it. So, all of this happens at the stage of discovery and production. Just keep these words in mind. We look into a little bit detail later on. Fine? Okay. So, now the trial has started. At the trial stage, we can say that there will be arguments. What are arguments? Arguments by the plaintiff first, or the plaintiff's lawyer, and then arguments by the defendant's lawyer. This stage is reserved purely for the purpose of explaining what exactly is present in your plain and written statement. Because till now you kept submitting documents and evidence only. At this stage you have a point, you have the thing to argue before the court of law. And from what I know, in most cases in the civil courts, there is not much in terms of arguments based on law. Arguments based on law will mostly happen at the high court level, or the high court and the Supreme Court level. At the lower court level, they will simply say this is the application of facts to this law and this is only the decision. So, I am not saying that there is no arguments in the lower court stage. I am just saying the arguments will vary slightly differently in comparison to a civil court and a high court. But fine, let's stick to what arguments are. Arguments are done first by the plaintiff, followed by the defendant. Now, every time arguments are made, there has to be counter arguments. So, arguments includes counter arguments. It's a process. Plaintiff, defendant. Then plaintiff will have a chance to rebut the defendant. Defendant will have a chance to rebut the plaintiff. After that, remember the evidence that you did not submit at the stage of plaint and the evidence, plaint and the written statement. You have to submit all of that evidence at this stage. Because if you don't submit it at this stage, then there's really no point. Okay. So, this evidence will be submitted at this stage. But also one more thing is there, that is rebuttal of evidence. What can be a rebuttal of evidence? If it's a document, you can say that no, this document is forged, or this document is not real, or this document is not properly stamped. Or in the case of certain other types of evidence, you can say that this evidence is not even permitted by law to be given. Or like I said, we follow Evidence Act with respect to what can be given and what cannot be given. So if it is an evidence which is prohibited by law, then you can't submit that before the court. So this is the stage of rebuttal of evidence. Okay. There's something known as a cross-examination. Cross-examinations are fun to watch if it's a fun case. Okay, I won't call anything a fun case, but what exactly is a cross-examination is that until this point also, the plaintiff and defendant may not even be required to turn up before the court of law. They can simply authorize their legal representative, that's their advocates, to appear on behalf of them. Now, unless the court specifically says, no, I want the plaintiff before me, or I want to see the defendant before me, unless they specifically call for an appearance, these people need not turn up before the court. You can give enough reasons to say that no, they're coming from a different state, it may not be possible, etc. Like I said, it is an if or situation. But at the cross-examination stage, it is a compulsory requirement for the plaintiff to be present or the defendant to be present. Why is because they place the plaintiff himself on the witness box, and then the defendant's lawyer will come and cross-examine. They will verify each and every fact that is being stated wherever he has mentioned it, whether it is the plaint, whether it is the evidence or certain other additional documents that are given. It's like I said, it's fun to watch because remember, it's a fact-finding stage. You can lie as much as you want on paper, but when present in front of another person and when being asked certain questions, your body language and certain other truths will come out. So literally, if there's a case of let's say a woman has filed a case of domestic violence against the husband. Now, sounds serious? Domestic violence? But the only domestic violence that has happened is she slipped, fell down, scratched her hand, and fell down on the floor. Is that domestic violence? But then how did they write it in the plaint? The defendant accosted me at a great speed. I fell back at a force which caused me to suffer great harm. You can write it very differently to make it sound extremely big. But then really what happened? It was an accident where she tripped, she fell and she hurt her hand, but then she's blaming the defendant for domestic violence. All of these can be found out at the cross-examination stage. Now, if a person is lying about their property, how did they obtain the property, or how did they obtain the goods? They would have lied saying, no, I bought it through legal means, but actually it would have been acquired through theft. That can be found out if the lawyers know how to cross-examine properly, because it will all come out, and those are accepted as evidence. So cross-examination is actually a very, very important stage in a suit, again for the purpose of fact-finding. Okay, are we clear at this trial stage? This trial stage is the longest stage actually, because hearings, counter-arguments, all of these will take place. And once all of these are done, both plaintiff and defendant have given their end of the story, finally it comes down again to the court of law to pass what? A judgment. Now, the judgment, please remember, is only a statement affecting the rights and liabilities of the parties. It is only a statement in a court of law. What do I mean by affecting the rights and liabilities of the parties? Plaintiff had a right. The question is whether it was actually violated or not. If there is a violation of rights, then the defendant now has to do a remedy. He has to either pay compensation or return the goods or recompensate something back. So now can I say that the defendant is now liable to pay up money, to pay up compensation to the plaintiff? Then more importantly, when I say rights and liabilities, the court itself is saying, listen, this is this person's right, it got violated, you are now liable to pay up the compensation. Or they can say the right was not violated and that the plaintiff himself was harassing the defendant. And so the plaintiff has to pay up costs to the defendant. There are very rare case scenarios where the plaintiff itself has gone and filed a suit and the plaintiff itself has been punished for it. It happened in one case actually where I'm not getting the name of that actress, but she went and filed a suit against 5G network, against like all the companies setting up 5G, claiming that it is harmful to the health of individuals. It was not well researched and she didn't have proper evidence. And finally, when it went to the court of law, the court ended up finding her itself, saying that she was wasting the court's time by harassing the court as well as the defendants by putting baseless allegations against them. This is very rare case scenarios where the court will actually punish the plaintiff itself for coming before the court. But most times what will happen, the court will end up punishing the defendant, or they'll simply say, I don't find any violation over here and I'm not going to grant any damages. It can go in multiple ways. But finally, that is determining rights and liabilities. Who has a right, who has a liability, that is only a judgment. Okay? Judgment is not the final stage in a suit. After the judgment comes something known as a decree. Now, for the word decree, there is a very extensive definition for this. We will look at this definition a little later on, but we can say that this is the final decision of the court with proper jurisdiction. Decrees itself are of two types. A preliminary decree and a final decree. Okay. Again, here I am moving into a example. We are going back with the example of Ashray and Akash. So what did we see as the example? 1 acre of land. This belongs to Akshay and this belongs to Akash. Correct? But what has Akash gone and done? Akash has entered into a sale agreement with, say, one Pradeep. Over what? The full 2 acres of land. Okay. He has started with the proceedings of sale. Now the question is whether Akash is even the real owner of the full 2 acres. Now tell me, can you sell something that does not belong to you? No. It's called theft then. Because if you cannot establish that you are the owner, then this is a clear case of theft. And we will study many principles moving forward. If you are not the proper owner to the property, you cannot sell it. Okay. Now what happens is, Akshay goes and files a suit against Akash. Okay. Sorry. Yeah, Akshay. I changed the names. My bad. Let's keep it as Akshay and Akash itself. It was supposed to be Akshay, Akash and Ashray or something. Fine. We'll go with the same example. Okay. Now he is selling the land. Fine. But by the time Akshay goes to the court of law, files a plaint, 30 days later summons is sent, 30 days later written statement is given, another 30 days later issues are formed, and then when they decide to call for arguments, etc., anyways a minimum of 4 months is going to go by. By then, one of the brothers here, Akash, sells the land. Then can you still be fighting over something once the land is sold? Does it make any sense? Because then Pradeep will also now get involved in this suit. Whereas technically he didn't do anything wrong. He assumed that I bought it from the proper owner. So don't you think some kind of a remedy should be given to Akshay immediately? Yes? Can he be waiting for the final decree to be given before this property can be, his half of the property can be given back to him? He can't wait that long, because a sale can happen in one day, it can happen in a few hours, or it can happen in a month also. Whatever it is, he cannot wait. So don't you think he needs some kind of an interim remedy, immediate remedy? Right now I need the court to do something for me. So when we're going with this example, let's see who is going to be the plaintiff in this case. Akshay is going to be the plaintiff. He has to go to the court of law with the right jurisdiction. Against whom? Akash. Okay. Now Akshay has filed the plaint. But please remember, the court is required to send the summons only within 30 days. But it looks like Akash is going to make a sale of property immediately. So what the law is saying is that Akshay can also file an interim application claiming what? Claiming stop the sale of this land. or in other words, he is asking for an injunction. Have you all heard of the word injunction anywhere? Yes? Stay order. Stay or put a stop to whatever is happening right now. And so, when should Akshay file this interim application? He can file it anytime after the plaint has been instituted. Or literally even at the time of institution of plaint, he can say, Your Honor, this is such an urgent matter that if I don't get a remedy immediately, then I will be inconvenienced to the greater extent. So then any time after he has given the plaint, he can submit the interim application. Are you all understanding so far? And if Akshay has asked for an interim application, the court will respond with granting him an order. What is the order? The order of injunction. Sorry. Okay. So injunction has been granted. Now what will happen in this matter? This sale will come to a stop. Fine. And then you can proceed with the suit as you need to proceed. Send the summons, get the written statement, all of that will proceed. Okay. Now, following the same example, let's say that the court comes down to a final decree. The decree is ruled in favor of Akshay, stating that Akshay is the true owner of 1 acre of land. Now, there are a lot of procedures related to this property. The court can say, yes, you are the owner of 1 acre of land. But is it enough that the court simply says this? Right now, the brother Akash is living on the property. Akash is the one who has the documents related to the property. And right now, the property is as a 2 acres whole. You are not able to partition it into 2 parts. Rather, it's being held together. So, a lot of procedural requirements to ensure that Akshay gets his part and Akash gets his part. Okay. So, what they will do at this stage of decree is that Akshay will apply for the execution of decree. What does it mean to execute a decree? Carry it out. Exactly. So now the court has given the decree, but remember, one of the brothers is still living on the property. How do you ensure that he vacates the property, that it's split in half, and 1/2 of it is given to the rightful owner? The decree holder over here will end up applying for an execution of decree. In short, we call it as an execution petition. Now, the court will oversee the process. The court will give them, say, 3 to 6 months time to ensure that they have vacated the property, partitioned it, and Akshay has now been granted his 1 acre. Okay, so this is all at a preliminary stage of the decree that's happening. And then once it is fully completed, also remember that the court can even grant damages. Akshay can claim things saying that, see, my right as the owner of the property is violated. And as the owner of this property, I am entitled to damages. Plus remember, Akshay had to pay court fee, he had to pay stamp duty, he had to incur so many litigation costs, whether it is travelling to the court, appointment of a lawyer, appointment of junior advocates, that many appearances before the court. This is what we call as litigation costs. So he will even ask the court, Your Honor, I want to be reimbursed for my litigation costs. because that person caused me harm, and now to recover my property I have had to endure so much expenses. So the court can even grant that. They may say that you have to pay so much money to Akshay. What if the money amounts to 1 or 2 lakh rupees? I'm just saying as an example. It can be as low as 10,000, 20,000. It can be a much higher amount also. Now he has to transfer that money, right? And the court has to oversee the actual transfer of that money. And this is what execution of a decree does. So whether it's immovable property, movable goods, any other cause of action, the court will end up overseeing the process. And then finally, they will give the final decree. Using this example, I've tried to explain 2 things to you. One is, what do you mean by an execution petition, and what do you mean by an interim application and order? Okay, so let's just recap whatever we've done so far. Again, we're looking at point of view of once the issues get formed, that is where we stopped the last revision. After the issues get formed, again, what are issues? Whatever is questions which are framed by the judge, correct? Whatever is alleged by the plaintiff and rejected by the defendant or denied by the defendant will be the basis of issues. Based on this, there will be arguments by the plaintiff and defendant. There will be counter arguments, cross-examinations, submission of evidence, rebuttal of evidence. Everything will happen at this stage. Once this stage is over, the judgment is given. Judgment is merely a statement. If you have to know the difference between a judgment and a decree, judgment is a statement, whereas decree is the final document which is given by the court of law. Judgment determines the rights and liabilities of parties. It creates new liabilities, or it merely supports existing rights. The decree is only the final decision of the court with proper jurisdiction. So this decree can be at a preliminary decree and a final decree. When will we say there's a difference between preliminary and final? When there is a stage of execution that is required to be done. So normally the judgment holder or the decree holder will apply for execution proceedings to execute the decision of the court. And then once the entire process is completed, the court will give the final decree. Okay, and that final decree is only it's a document which is stating, in this court of law, these are the facts, these are arguments, the reasoning of the judges, and what was finally held in the judgment. Okay, this is only your proceedings before the court of law, all the way from submission of a plaint till the receipt of a decree. Any doubts so far? Please also note this down, okay? Just note this as a side note. If you submit a plaint, you will get a decree. If you submit an interim application, you will get an order. Okay? What is the difference between a decree and order? There is no difference. They are the same. The only difference is an order is of a temporary nature, and it is given during the pendency of the suit. Whereas decree is of a final nature. Everyone clear with the process so far? Okay. From here we are going to see slight variations. What happens if this happens, or what happens if that happens? But I am only going to vary from this existing flowchart that we have seen, from submission of a plaint till the decree. So if I am talking to you about summons, you should automatically remember it is the second stage of the suit. Or if I am talking about a written statement, it's the third stage. Okay. By now, or when you go back home, make sure to just recollect these terminologies. And when you are studying CPC, if you give each topic to each stage, it is much easier for you to remember what comes at which stage. Okay. Now let's move on to our variations. Now from this point, I am going to just keep giving you multiple variations of this entire proceeding. Okay. Variation number 1. You don't need to write it as variation 1. I am writing it for the purpose of explanation. What happens if the plaintiff goes to the court with the wrong jurisdiction? Plaintiff has approached court with no jurisdiction. What happens in this case? When will they even find out that the court doesn't have jurisdiction? Okay, it's not an automatic process. It's not like, oh, you submit your plaint, your written statement, AI scans the whole thing and says there's no jurisdiction. No. You remember I told you at the stage of forming issues, the court asks the first question, whether this court has the jurisdiction to hear this matter, or whether the court has the locus standi to decide this matter. Now that stage itself, at that stage, the court can actually determine, I am sorry, I do not have the power to hear your matter. And the court will end up asking you to go to the court with the correct jurisdiction. Okay. And I want you to remember one provision in Limitation Act. Remember in section 9 we studied about continuous running of time, and that the exceptions to that section 9, we studied section 12 to 16. In one of those sections we saw that the time taken bona fide in a court without jurisdiction is not to be counted for your limitation. Okay, and you can see at this stage, it's not at the stage of plaint or written statement, but rather after the issues are formed and it's being decided by the court of law, the court is deciding, I'm sorry, I cannot determine your liabilities and rights. I'm asking you to go to the correct court of law. Okay, so this is what happens if the plaintiff has approached the court without jurisdiction. They'll simply direct you to the correct court. Now, what if the plaintiff, let's say the cause of action is non-payment of what am I writing? For supply of goods. In short, there is a breach of contract. Please understand the cause of action. What is the cause of action? The time at which the plaintiff's right got violated. Okay. So when did it get violated? By a breach of contract. Simple. And what is that breach of contract? Non-payment of money for supply of goods. Try answering this question. Which is the section relating to jurisdiction over movable property? Section 19. What is immovable property? 16, 17, 18. All others are 20, and pecuniary jurisdiction is section 15. Okay, fine. So technically this cause of action will come under section number 19 you have to look at. But our plaintiff here, what he decides to do is, he decides to go and file a suit in two different courts of law. So let's call our plaintiff again known as Akshay, approaches the court in Tamil Nadu against the defendant. Akshay also approaches the court in, say, Bangalore against the defendant. Now, as to the why, we will study about when we are looking at jurisdiction. But he has instituted a plaint in two separate plaints, that is, in two different courts of law against the same defendant. Okay? Can he do this? He can't do this. Why? Wasting the time of the court. One more reason? Yeah. True. But we'll come to that later. One very logical reasoning as to why two courts cannot hear the same matter. Court in Tamil Nadu can rule in favor of Akshay. Court in Bangalore can rule in favor of the defendant. So then, which ruling do you follow? And please understand that we are assuming that both the courts have jurisdiction to try the matter. The question is, can both the courts hear the matter at the same time? The answer is no. But the question is, does it happen? Definitely yes. You will have people instituting suits wherever they feel like. Now, if they have proper legal counsel, they are not supposed to do it and they will go to the court with right jurisdiction. But what happens if both these courts are hearing the same matter? They won't even realize it until after some time. So, let's just say, 1 minute. I will call this as suit number 1 and suit number 2. Okay. What do I do over here, or what does the court do over here? Now, there is a provision of law which is approaching this rule and saying, if such a situation happens, I will provide you with a remedy. What is that remedy? That remedy is called res sub judice. Please take note of this term, res sub judice. Res sub judice is also known as stay of suit under section 10. What this principle of res sub judice is saying is that whichever suit was instituted first, or no, sorry, before going to that, if there are suits with the same cause of action, the same plaintiff and the same defendants, and the matter has been instituted twice in different courts of law, then whichever suit was instituted first can be heard by the court of law, and whichever suit was instituted the second will be put a stay to. So technically, let's assume the one in Bangalore was the second suit, and therefore a stay will be put on this suit. It's like saying you proceed with hearing one, but then you put a stay to the other. Now, how, when, what, that's what we look at right now. Let's say that the plaintiff went and filed the plaint before both courts of law. Now, it is only when the defendant is coming to approach the courts, he will have to appear before the Tamil Nadu court at an earlier date, because the plaintiff got instituted at an earlier date. Okay, so he will go to the Tamil Nadu court first, and then he will give his written statement. Then he will, if he ends up getting a summons even from the Bangalore court, what he will go before the Bangalore court and ask is, Your Honor, this matter has already been instituted before the Tamil Nadu courts, and that I ask that you put a stay to this suit until the Tamil Nadu court has given a decision. Okay, and it's a simple matter of put a pause to your proceedings. So what are the basic requirements of this section 10? Same cause of action, same parties to the suit, but two different courts. There is one former suit or the first suit, and there is a subsequent suit or a second suit. You have to put a stay to the subsequent suit while the former suit is being heard. Following? If the cause of action is different, then they are two separate matters, and they can be heard by the court separately. Okay, because each right has a remedy. You cannot say that even though the parties are the same, that every violation of right has to be heard in one court only. It can be heard in two separate courts. Now there is only, sorry, please finish writing and then I'll proceed. So I just want you to remember these terms, okay? In your textbook, they will keep using the word former suit and subsequent suit. A former suit is always the first one, the subsequent suit is always the later one. And it is the later suit or latter suit or subsequent suit which is put where a stay is asked for. Okay. Now there is only one exception to this rule, just one exception. If the trial has started, then you cannot put a stay to that suit. So let's say the trial. What is the trial stage? Plaint submitted, written statement submitted, issues are formed, and then the trial starts. Now let's say in the second suit the trial started, but in the first suit it has not yet started. Now what they are saying is that whichever suit the trial has started, don't stay that suit, put a stay to the other suit, regardless of whether it is the former or the subsequent one. Because remember, we are only trying to conserve the resources of our judiciary, and if they have already put in the efforts to start the trial, then you proceed with that court and then you put a stay to the other court. Please remember that both courts must have the jurisdiction in the first place to try it. If the court does not have the jurisdiction, then there is no question of stay of suit itself, but rather they have to go to the correct court. There will be situations where multiple courts end up having jurisdiction. So that time only this problem arises. Are we understood in this concept? So section 10, stay of suits, res sub judice. Where there is a former suit and a subsequent suit with the same cause of action, same parties to the suit, then the subsequent suit or the latter suit is stayed and the former suit is heard. Exception, if the trial has started, then you proceed with the trial of that suit itself and put a stay to the other suit. Have you understood the concept of res sub judice? Okay. We are now coming into the concept of res judicata, section 11, bar to further suit. Okay. Again, quickly tell me, what do you mean by double jeopardy? Can't be punished for the twice for the same offence. Where did we see that provision? Which fundamental right? Which fundamental right? 31. No. 31 is repealed, I'm sorry. 22, are you sure? Now you will tell me all the fundamental rights and you will make me itself confirm it. Okay, it's either 20 or 22. Which one? 20. Which subclause? 1, 2, 3. Second. 3 is self-incrimination. Yeah. Okay, that was not very important, but yeah, it's article number 20. But see, article 20 is a criminal law provision. It's a criminal law protection. So in criminal law, you are protected against double jeopardy. What then about civil law? Shouldn't the same concept apply to civil law also? It does apply through this principle of res judicata. It's just not given as a fundamental right, that's all. Why? Because criminal law sends you to jail and can even give you a death sentence. In civil law, you're not going to get a death sentence. Maximum forfeiture of property, payment of fines, that's the maximum extent of civil punishments that you're going to get. Okay, so coming to this concept of res judicata, it is the same concept as your double jeopardy. So what did we study under double jeopardy? No person can be punished for the same offence twice. Now while we studied that in one line, we are going to go into a lot of detail in CPC. Okay. In the principle of res judicata also, I want you to remember it from the concept of first suit and second suit. In the first suit also there is the plaintiff, I'll call him as P1, approaches the court of law against defendant 1. Okay. Why I am writing defendant 1 is to simply get you to understand that they are the same parties. Now, when approaching the first court of law, let's say this is in the year 2020, okay, the court passes a decision or a decree in favor of the plaintiff, and when he grants the decree in favor of the plaintiff, he asks the defendant to pay up, say, 50,000 rupees in damages. Now, can I say that this is a punishment which has been given to him? It has been finally decided, decree is given and he has been punished. Now, the same plaintiff approaches the same court of law or even a different court of law, that is not the matter here, against the defendant, punishing him for the same cause of action. Please understand, same parties, same cause of action, but in the first suit, the court finally decided the matter by issuing a decree, and as a result, the defendant was punished. Now, fast forward to the year 2022. He has again gone to the court of law for the same cause of action, and he is trying to institute a suit against this defendant. Should this second suit be allowed? The answer is a clear no. Why? Because no person can be punished for the same offence twice or the same tort twice, as you like to call it. Remember, wherever you see the word offence, it is a criminal law provision. You can't use it for civil matters. Okay. So let's understand what this res judicata is saying, or what are the basic conditions. One, it's the same parties before the same court of law or even a different court of law, same cause of action, and the first suit has been finally decided. Okay. Then the second suit, I will say, is barred by res judicata. That means the court will not even accept the further hearing of this matter. Yeah. Can we quickly see the difference between sub judice and res judicata? What do you think are the possible differences? Exactly. In res sub judice, none of the suits are yet decided, but in res judicata, one suit has been finally decided. That means a decree has been issued. That is essentially the only difference between res judicata and sub judice. But if you see the similarities between the two, there is a former suit, there is a subsequent suit. Same cause of action, same parties also. And they are trying to not punish the same defendant twice. In res sub judice, they are trying to have multiplicity of proceedings or excessive litigation. They are wasting the court's time. Whereas in res judicata, the objective is to protect the defendant from being punished for the same offence twice. Okay, so we see only one difference and most similarities if you think about it. So section 10 is sub judice, section 11 is res judicata. Okay. Let me just ask you one small question related to res judicata. Okay. Why do you think a person would go to a court of law the second time to punish the defendant? He's already got a remedy in the first suit. He already got 50,000 in damages. Why will he go again for a second suit? He can think that the compensation is not enough. That's one. He may think that in the first suit, I didn't have enough evidence. Now, let me just tell you this little bit, okay? If, let's take example of Lakshita's water bottle again. Okay, Lakshita is claiming that water bottle was stolen. And she says, Anuja stole the water bottle. Now, I'm like, show the proof. She doesn't have proof. She doesn't have direct proof that I walked into this class, took her water bottle and left. But what she does know is that while the water bottle was in class, I was the only person in the academy at that time. So while there's no direct proof that I took her water bottle, there is a circumstantial proof saying that I would have been the only person in the academy. So therefore, I am probably the person who stole the bottle. So where there is no direct proof, they can't punish me to that extent. Okay, they can't be like pay up 2,000 rupees in fine. They can simply say return the water bottle to her. Okay. Now Lakshita finds out that there was a video recording of this class. That there's a camera in this class and she's caught hold of the file. But please understand, the first decree has already been given. The court has finally punished me. But she has come across a new piece of evidence. Do you think she can file a new suit because she's found new evidence? No. Who and all are saying no? 1, 2, everyone. Everyone saying no. Anyone saying yes? Okay, no one's saying yes. Fine. You cannot file a suit like this even though you didn't give the proper evidence at that time. Because had she given the evidence, I would have been punished to the full extent of the law. But there was no evidence at that time. So therefore, we can say that even though a new evidence was found, that doesn't mean they can go and file a new suit. This is one such example. Second is, if the cause of action varies, then there is no res judicata here. There is only a new, every time there's a new cause of action, there's a new suit liable to be instituted. So tell me one thing, income tax. Income tax is paid in what duration? Every year. So for 23-24 we will pay in 24-25. For 24-25 we pay in 25-26. Now let's say I am the assessee. I didn't pay my income tax for 23-24 and 24 and 25. Are they two separate causes of action? I'll repeat myself. I didn't pay for 23-24, 1 year. Then the next year also, 24-25 also, I didn't pay. Yeah. Are they two separate causes of action or are they a single cause of action? They are two separate causes of action. So can you understand when I'm saying they have to be two separate ones? In the sense that one right violated. But in this case, it's not a right, like income tax. Non-payment of my income tax the first time is a violation. Then when I do it for the subsequent year, second cause of action. Then third cause of action. So the IT department can file 3 different suits against me if I don't pay for 3 different years. And I cannot say, no, you are barred from ever filing a suit against me because you already filed a suit against me last year. Okay. So I hope this part is clear for you. Okay. We'll stop here. Okay. I'm not done yet. We'll be studying a little bit more in the next class. But I'd like you to go back and do a reading of the following points. Okay. If you can open out your textbook. Okay, I'd like you all to do a reading of all of these points, okay, whether it is through the notes I send you or even through the textbook. Start out with the introduction, aim and scope of CPC, what the scheme of the code is. You can go through the definitions, but if you want, you can also wait for me to finish it enter into the next class. But I just like you to do a reading of it. Okay, so definitions you can slightly ignore for the time being. Start with structure of the civil courts. I've gone down past the definitions. Structure of civil courts, stay of suit, section 10, sub judice. Please make sure to study these properly, the essential conditions of stay of suit. And I want you to read all of the, actually not this, case laws, everything. Stay of suit and res judicata are very, very important. And hence res judicata section 11. Okay. Now in section 11, please read till you may read till here. Okay, that is all of the essential, the following requirements are necessary. Point 1, 2, 3, 4. Okay. After that, we will go into it as a variation under res judicata. Each one is slightly important, but we will discuss it later on. Okay. Start reading from here. In the notes that I share with you, I have clearly made a distinguishment between explanation 1, explanation 2, 3, 4, explanation 5, 6, 7, 8, all of that I have specified in the notes also. So, make sure to do a reading of that. And conditions. Conditions of sub judice, conditions of res judicata is very important. Okay. Then I want you to do the full topic on jurisdiction. Your jurisdiction covers the 4 topics that you see before you. After that, whether it's original appellate, criminal and appellate jurisdiction, section 15, place of suing, section 16, section 17, 18, 19, 20. You need to be thorough with till this point. Okay. I'd be very happy if you all read the full chapter. So, surprise me a little bit next time in class. You all can read a little bit more also and come. Okay. But since I'll be meeting you all only next week, study these thoroughly. Make sure to know jurisdiction, res judicata, sub judice, all of that properly. And I'd like you all to come down a little bit. This institution of the suit, sorry, not institution of the suit, my bad. Just do a reading of this topic, important stages in proceedings of a suit. It's a big table in your chapter, just this part. I want you to study this, if it's presentation of a plaint, what order of the order 4, summons order 5. I want you to remember that thoroughly. And this is very similar to the flowchart that I have presented for you, all the way from plaint till giving of the judgment. Okay, so are we clear on what and all needs to be studied?